So today's topic is impeachment, right? And when most of us think impeachment, we think of presidential impeachment, right? That's the thing that we've always heard about. You impeach a president. Um, in legal terms, impeachment is a little bit different, right? Impeachment merely means discrediting a witness. Now, there are specific steps that you should go through in discrediting a witness, and we'll talk about those. But the idea here is not to get the person taken off the stand or anything like that, but to show the jury this person may have a reason to lie or is being dishonest or whatever. So let's jump in. So the federal rules of evidence and case law recognize 7 categories of impeachment. Now, the first 6 can be raised during cross-examination of a lay witness, and then treatises that is a little beyond the scope of this course, so we won't get into that. But the ones that are in yellow or gold, we will get into. So you can impeach a witness, discredit a witness by showing that they have a bias, an interest, or a motive in testifying the way they're testifying. Now, this does not have a correlation to the federal rules of evidence. Instead, it is found in case law. You also show that the person on the stand, the lay witness, has made prior inconsistent statements. Now, this is found in Federal Rules of Evidence 613. Right, so this occurs when a witness says one thing at one point, maybe to police officers, and then says something completely different on the stand, right? You probably want to point that out for the jury. Also look at contradictory facts, right? So if we've accepted things as fact and the person starts testifying that they're not fact or something else along those lines, we can say, well, this is what the evidence shows. Are you sure? And again, this doesn't have any rule that corresponds with it. Instead, it's case law. We'll talk about prior convictions, when you can use them, when you can't use them. And that's Federal Rules of Evidence 609. We'll talk about prior bad acts, Federal Rule of Evidence 608B. And then bad character for truthfulness, Federal Rule 608A. And again, treatises generally are reserved for expert witnesses. And beyond the scope of this course. So let's start looking at first thing that we can impeach a witness with, right? It's bias, interest, and motive. So bias, interest, and motive refer to the relationship that parties have or the issues in a lawsuit that could cause a witness to consciously, and this is important, or subconsciously slant their testimony one way or another. Right? So bias is this idea of a predisposition that causes a witness to have, prefer one of many parties in the case, right? So bias, it's difficult to show because jurors don't usually like it, but if you can make the argument for bias by the police officers, you can. Because generally speaking, police officers tend to have a bias towards the prosecution. Right? After all, they're the ones who made the arrest, they're the ones who investigated, etc. So they have a predisposition. And again, this might not even be conscious. It can be subconscious, right? And it doesn't have to be blatant lies or blatant statements. It can be just a slant, right? So set of facts, and you kind of just put a little bit of a spin on them. Well, there you go, right? So we can show bias in that manner. Interest. So this is usually a relationship, primarily financial, that causes a witness to prefer one side over another. For example, a witness is an employee of a corporation in a lawsuit. They're probably going to prefer their boss, right, their corporation, because they want to maintain a long-standing interest. Now, another interest that you could suggest applies is when you have snitches or informants, right? Usually they're going to have a financial interest or at least some other interest, such as reduced sentencing, reduced charges, what have you. And it causes them to prefer one side, and again, this case is usually prosecution over another. And then we have motive. So a motive is different than bias and interests. It's a person's predisposition to testify in a certain way because of personal reasons, such as love, hatred, or revenge, right? So think about your, there's a lawsuit, and one of the witnesses, or excuse me, two of the witnesses were married at one point. They went through a very, very nasty divorce. Now they're kind of testifying on different sides of the lawsuit. Guess what I'm going to do, right? I'm going to pull out, you hate this person, this is revenge, right? And just try to make the person look as dishonest or as predisposed to a certain outcome as possible. Right, so again, this includes love, hatred, revenge, you name it. Anybody can have a motive. If you discover a motive, and you can, in most cases, discover a motive, you have to milk it, but you have to be cautious that you don't oversell it or overplay your hand, right? Because let's say the parties went through a nasty divorce, but they have a kid, and they get along really well now, as basically friends, because they have that child in common. Well, if you start talking about their divorce, the other side's going to bring up, yeah, but aren't you friends now, right? Haven't things gone smoothly? Aren't you communicating and interacting better? So motive is definitely one you can find in virtually every case. At least someone has a motive. But you have to be careful on how strong you play your hand. So this brings us to 613, right? So the first one is case law. This is in the Federal Rules of Evidence. This is a prior inconsistent statement, right? So this is the most common method of impeachment in which a witness testifies about something at trial, but said something different or failed to say anything at an earlier time, right? And again, the idea is your job is to detract from their credibility. Now, there's an effective technique to impeach someone. It's based upon what's called the 3 C's, accompanied by an appropriate attitude, right? So we'll talk about attitude in a second, but we'll talk about it now. Attitude is very, very important. We're talking about a prior inconsistent statement for numerous reasons, right? Are you trying to show that this person is lying? Right, then you might take a more aggressive tone. Or does this person maybe have dementia and you're showing that they can't remember or they misremembered? Well, you're probably not going to have an aggressive tone, right? You're going to have a sympathetic tone. Just because you're showing that somebody's lying doesn't mean the jury's not going to hate you, right? So you have to walk that fine line of, I'm trying to prove my point and show the jury this person is not credible, but at the same time, I don't want to alienate the jury, right? So basically, the 3 C's begins with a commitment, right? So the witness will say something on direct or maybe even cross, but usually on direct, that you want to now impeach them with, right? Because they said something, they said some kind of fact, and in an earlier deposition or affidavit or something along those lines, you know, because you know your case, that that's not what that person said before, right? So the first thing we want to do is we want to be specific, focused, and short. Okay? So I will pull up in a moment a really great tool that you can use when you're trying to impeach a witness. But the idea is you make them commit to the things that they said, right? So you basically say, well, on direct examination, you testified that X, Y, and Z. Isn't that correct? And then you kind of go into this, like, and you sort of tell the truth, the whole truth, and the truth, blah, blah, blah. Do you remember giving a prior statement in this case? Right? And then you start to like tear them down. The first thing to do is make sure that you commit them to the thing that they said, because maybe they misspoke. It happens all the time. Maybe they change course, right? Back to being favorable towards you. Who knows? They can make themselves look uncredible to the jury. So you also don't want them to turn around and say, well, that's not what I said, or that's not what I meant, right? Because you can always have a stenographer read back what they said. But if they say, well, that's not what I meant. What I meant was blah, 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 blah. Well, then commitments, I mean, you've lost that opportunity, right? Because you've given them a way to weasel out of it. So you're very direct, very blunt. Don't give them the opportunity to explain. Just say, on direct examination, you said X, Y, and Z. Isn't that true? And then move on. Now, if they say no, have the court's stenographer read back their own testimony, right? And they've kind of impeached themselves. So first thing to do is very specific, very focused, very short, right? So you don't want to, I mean, you can impeach people multiple times, but you don't want to go down the trail of making something overly broad, very long, something that doesn't necessarily hold people's attention, right? You want to be kind of snappy with it and show, oh, you know, you're being dishonest, or you said something different, and just kind of quick fire. And you can do this in a number of ways if you know your case well enough, right? And I'll show you the tool in a minute that we use. Again, at this point, you consider tone, right? Because if you're trying to show that they are purposely lying, you're probably going to come in with a harsh tone. But at the same time, you don't want to cue them to the fact that you're about to destroy them. So maybe you don't, right? Every witness is different, and you kind of have to feel your way through. But when you commit somebody to something, usually it's going to be based upon what you're trying to show, right? Are they lying? Are they misremembering? Has it been 3 years since they gave that statement and they probably don't remember exactly what happened? Those are very different scenarios where you're going to take on a very different tone. So after we commit somebody, right, then we get to the second C, which is credit. So what you do is you build the source of the impeaching statement for the jurors, because the jurors need to know where, when, and how the prior inconsistent statement was made. Now, there are several examples in your book. We'll talk about how we build the credit when I show you the kind of cheat sheet in a minute, but you can read the dialogue and see how you build somebody up as to when they said this other thing, right? And again, if you're trying to show lying, you're probably going to be more strict, more severe in what you're saying than if you were just saying, oh, you misremembered, right? So jury, they can't really remember what happened. It's not really credible. That's a big difference. And so after we've committed them to a statement and we have told the jurors where, when, and how they made this statement, then we get to the third C, which is the most fun, which is confront. Right, so this is when we actually bring out the prior inconsistent statement and ask a witness to admit making it. It's the fun part, right? It's kind of it's almost like the Perry Mason moment, where you reach down, you pull out their affidavit, and you say, I have the statement right here, right? Follow along with me as I read what you said previously. And you confront them with it, right? So this brings us to kind of the last point before we'll look at the tool is stop. And this is where lawyers get into trouble because they don't know when to stop, right? So once you finish the 3 C's, you've confronted the person, let that impeachment linger in the air for a few moments, and do not ask follow-up questions. If you do, you can bet that witness is going to try to save face, and they're going to go off on a tangent trying to explain what they said or start an argument, something along these lines. You get a chance at redirect and recross. So if you need to confront somebody again, then do it then. But there's kind of 2 schools of thought here. One is you confront the person with the statement, and maybe you want to stop, right? Maybe you just want to show that, hey, they're lying, or they don't know, or they don't remember. Or you could try to go for the gold, which generally I don't recommend, and say, so were you lying then, or are you lying now? Right, you're going to get an objection immediately from the opposing counsel, right? And it'll be a valid objection. Depending on what you're trying to show, it might not necessarily be wise to do this, right? Because if the person literally just forgot, and have you ever forgotten something? Happened to me before, like, yeah. Or are you trying to show that they're lying? Now, if you've done your job correctly, you shouldn't have to ask that question, right? So you bring out the inconsistent statement. You maybe then fumble through your papers for a few moments, letting the jury kind of take in the fact that this person is like given an inconsistent statement. And then you either follow up with another inconsistent statement, or you move on with your cross-examination. So the tool I want to show you, I will pull up here. Let's see. Okay, so this is a tool that is usable in mock trial. It's a really great tool, especially if you have co-counsel, right? If you're having a trial, you're probably gonna have co-counsel. Co-counsel is there to fill this out for you. So that way, if you're questioning a witness and then they say something different on cross-examination than they said on direct, your co-counsel is looking for that. And then you just follow these steps, right? So step 1, a witness testifies to something on direct examination that differs from their deposition. You write it down and you hand it to co-counsel. All right. Step 2, co-counsel reviews the deposition. If there's a clear inconsistency, write a large no in the space below. And if there's a clear inconsistency, write yes. Then step 3, co-counsel writes out exactly what the witness said in the space below at line 1. Co-counsel enters the appropriate page, paragraph, and line number at line 8 below, and marks the place in the deposition and returns the form to main counsel. So then you start your questioning. Isn't it true that, and this is where you say, you said X, Y, and Z. Then they might argue with you, or you might trap them, and then you say, so you're saying it's not true that you said X, Y, or Z, correct? You gave a deposition in this case, correct? And it was under oath? And you swore to give an accurate description of the events? You were given a copy of your deposition so you could check it for accuracy and completeness and correct any errors, correct? Then you signed the deposition swearing it was accurate, correct? Now, in your deposition on page number 1, paragraph number 2, you testified that X, Y, and Z, didn't you? Now, if the witness, and this is where it's fun, if the witness waffles and they're like, oh crap, I just got caught, you can say, well, let me help refresh your memory, right? And you get the deposition, the actual deposition from co-counsel, and you say, isn't it true that during this deposition, you were asked the following question and gave the following answer? And then you read the question and you give the answer. And you might have another copy for them so they can read it. So you read along with me silently as I go through your deposition. If they inexplicably deny it, that's what they said, then I'd mark this deposition as an exhibit, right, and move it into evidence where the portion of the witness testifies that X, Y, and Z, right? So the idea is if you nail them, awesome. That's all you need to do, right? Because the jury's gonna be like, what? He said one thing and said something else? And that's all you need. But if they start to argue with you that if you didn't do it, they didn't say that, then move the deposition into evidence, right? So that way the jury gets evidence and can see it again and remind them, oh yeah, that's right, he said this, but then he didn't say this. And you've, by this point, read the fact they have said something that was maybe in your favor or something along those lines, or something that's blatantly untrue. You have said it 3-4 times. You've made your point, right? And so the idea is when you get to 10, then you stop. So we're talking about prior inconsistent statements. There are different types. So there are oral statements, right? So this is probably the most common. This is when the police officer is talking to a witness or an investigator or family or friends or coworkers about something they've witnessed, right? So they're just trying to get information. Now, this becomes possible grounds for impeachment if the witness says something different while testifying, right? You cannot use someone else's statement, like a police report, to impeach a witness. Now I'll say that again. You cannot use someone else's statement, and this is the big one, like a police report, to impeach the witness. So you can't say, well, police report says that you said X, Y, and Z. It's going to be objected to for improper impeachment, and also that witness is going to say, well, that's not what I said, right? And there's no way of really proving it. We have to be able to show that that witness actually said something different. That's where oral statements kind of get tricky. That being said, we can impeach someone with their oral statement to the police in this way. Didn't you tell the police officer that the Chevy was going 50 miles per hour? Right? Now, you have the police report in your hand. You're not asking specifically what the police report says. You're just asking, well, didn't you tell the police officer this? You need to have that paper in your hand because that witness is going to watch you and they're going to see that piece of paper. And they're going to know that you know that they're being dishonest or something along those lines. If it reaches this point and they still deny it, you've kind of bluffed, right? Like you can't say, well, in the police report it says blah, 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 blah. And generally speaking, police reports are hearsay anyway. So it becomes a little bit of a problem, but it's something that you should mark down and take note of for cross-examining or examining the officer, right, who got the statement, and something to take note of for your arguments in closing arguments, right, that you can point out the discrepancy and bring it back and kind of impeach them sort of in the closing arguments. Then we have written statements. This includes statements that the witness writes or signs, as well as statements that are written or typed by someone else that the witness signs, right? So in order to impeach a witness with a written statement, you must have the statement marked as an exhibit. You have to show it to opposing counsel and show it to the witness before you use it to impeach them, right? So you're not asking any questions at this point beyond, Your Honor, may I approach opposing counsel and the witness in turn? And then you show them you show opposing counsel what exactly you're doing with what you're doing. Or you show them the line number, and you go and hand it to the witness. Now, you don't let the witness start talking about, well, but you don't say, oh, I'm going to use this line right here. No, what you do is you hand them the witness, and you say to the witness, Mr. So-and-so, please read along with me silently as I read page number 17, paragraph 3, line 4. And the lawyer should read the impeaching part of the statement out loud to the witness, not the witness, right? Because the witness, if they're smart, they'll either start to explain it, which hurts and kind of like damages what you've done, or they will keep going and read parts of their statement that maybe you don't want read. They might try to contextualize it, and maybe that's what you don't want. Like, let the other lawyer contextualize it, don't let them contextualize it. And when it comes to reading it, your volume, your inflection, and your body language should suggest the magnitude of the impeachment, right? So if they stumbled over something that was like relatively insignificant, but like you don't have anything else, you're going to do it, but you're going to do it in a fairly nice manner, right? If, however, they've changed their testimony and suddenly now, before they said it was somebody that couldn't have met the witness's description, or the defendant's description, and now they say, oh, it was the defendant, I know it, I saw him. And that's when you go, all right, we're making this a big to-do, right? So it's, you said before that it couldn't have been the defendant, right? Right, and like you kind of give that inflection, that body language, that more aggressive stance, because this is a major point, and the person is, again, probably lying or maybe even confused, but you're trying to show to the jury, hey, jury, wake up, this is a really big deal. So again, you should consider before you impeach one, whether impeachment's appropriate. It's not appropriate in every circumstance. And two, how you should portray that impeachment, right? If it's small, keep it small. If it's big, make it big. Most of them are middle ground, right? Now, you have some lawyers who will impeach on every single thing someone says. Guess what? You want to know how you piss off the jury? Do that. Right, so you should generally select a few points for impeachment, maybe even just one large one. Again, depending on the facts of your case, and cases vary. But if you're sitting there and you do 10 impeachments and the witness is only on the stand for 30 minutes, that jury's going to hate you, because you're going to go through that same process, that little worksheet we looked at, several times. Like, you're going to do it every time. And so, like, it's just going to get old. So, you know, that's where, again, you stop, but you also have to know your jury, and you have to know the case to say, okay, I feel comfortable now that the jury knows this person isn't telling the truth or is misremembering. I've done it 2 or 3 times now. I don't need to do it 7 more. Now, there is something that is a little problematic when we're talking statements, especially written statements. And we talked about this a little bit when we talked about some of the federal rules. Federal rule of evidence 106 is the doctrine of completeness, right? So FRE 106 provides that when a written or recorded statement is introduced, an adversary party may, quote, may require the introduction at that time of any other part or any other writing or recorded statement that in fairness ought to be considered at the same time, right? So what does this actually mean in real life? This is a protection against unfair impeachments, right? By having the witness read something out of context. Because let's say you're trying to get them to read something out of context, party's going to move and say, can the witness please read, like on their redirect or recross, whatever, read lines 17 through 18, and they only read like 16 through 15 before. It's the doctrine of completeness. It comes into play, right? And so does any other written or recorded statement. And again, this is a fairness test, right? That should be considered. So let's say the witness gave 3 depositions, right? It was a long, crazy case. And one deposition, they say one thing. Second deposition, they say another thing. The third deposition, they say the same thing as the second deposition. And then in court, they say the same thing as the second deposition, right? So like they pivot and they kind of plant. And you want that first deposition to come in because that helps you. And opposing counsel is going to say, you know what? This should come in and this should come in. You know, deposition 2, deposition 3 should come into evidence, be read on the record, because in all fairness, it helps. Well, in all fairness, it accurately portrays the witness's testimony, right? So this is what bites some people, is if they don't give the full account, or if they take it out of context, or if somebody's trying to take something out of context, this is when you say, all right, fine, take it out of context. Like if your objection gets overruled, that's fine. And then you just use the doctrine of completeness, right? And you just argue. And the thing is you're arguing and the jury's going to hear this, right? The jury's going to hear, like, there's other statements out there, or, well, Your Honor, this was taken clearly out of context. The doctrine of completeness suggests that. And like you say something fairly quickly, again, even if you get shot down, the jury's going to hear it, right? The jury's heard that there's something else out there, or maybe this statement is being taken out of context, and so they're going to remember that. Now, when we're talking again still types of statements, the most common situation involving impeachment usually requires interrogatory answers. And this is civil cases. Federal Rules of Civil Procedure 33B1 requires that answers be made, quote, in writing under oath, and, quote, signed by the person making them. So in civil cases, right, you get to do interrogatories. Interrogatories are basically just a list of questions, and you are limited to a certain number that you send to the other side, and the other side has to answer them. And then they send you questions, and then you have to answer them, right? When they do it, it's supposed to be done under oath, right? It's signed under the pains and penalties of perjury, et cetera, et cetera, et cetera. So this is usually where we have great impeachment material, because then we're talking about being under oath. Depositions are usually under oath as well. Beyond that, if you do an affidavit, it depends, right? So if it's an affidavit for a search warrant, it's signed under the pains and penalties of perjury. If it's an affidavit and it's not signed under the pains and penalties of perjury, then it's much more difficult, if not entirely improper, to bring it into testimony. So again, when talking about thing that we should note is also sworn transcripts, right? So whenever a witness testifies under oath and a transcript of the testimony is prepared by a court reporter, the transcript becomes a potential source of impeachment if the witness testifies differently at trial. So again, this is usually going to be depositions. But the thing that we have to take away from this is make sure the jury knows this person was under oath. They had time to review their statements, and then they signed it. Right? That's the big take home is not only are they lying, but jury, look, they had the time, they swore to tell the truth. While it was fresh in their mind, they read and reviewed it, and then they said, yes, under the pains and penalties of perjury, this is true. Now, jury, they're telling you something different. Right? So again, sworn transcripts come into play, interrogatories coming into play, and depositions come into play. Now, you can also impeach somebody by omission, right? So whenever a witness has made a report or record of an event, and the witness failed to put that report or record, the fact that he or she is now testifying about, the witness can be impeached by that omission. Right, so I'll say it again. Whenever a witness has made a report or record of an event, and that witness failed to put in that report or record the fact that he or she is now testifying about, that witness can be impeached by that omission. So this definitely comes into play when we're talking police reports, right? Because if the officer writes out a police report in great detail, as they're supposed to do, and they get on the stand and they say, oh yeah, also, they're not talking about the report, and say, oh yeah, and then I learned that X, Y, and Z occurred. You can get up there with their report because it's their statement and say, well, show me in this police report where you said X, Y, and Z occurred. But that's a fun one to do because the person's going to be really embarrassed. They're going to look at it. Even though they know they've been busted, they're looking at it, they're not reading it. They're trying to think of like what to say back. It's omissions are a little bit easier to do. And again, but you have to be sure that they didn't say it. Or even imply it, right? It has to be like, this is brand new information, what the hell kind of material. We also do contradictory facts, right? So whenever a witness says one thing at trial, the witness can be asked to admit a contradictory fact, right? So for example, a witness says that he was 20 feet away from the collision. He can be asked if he was more than 100 feet away. Okay? So impeachment by contradictory facts or impeachment by contradiction is well recognized in the case law, but there's no specific federal rule of evidence that governs it. Instead, there is a good faith requirement, right? And this is basically the cross-examiner cannot suggest a contradictory fact unless he or she has a good faith basis to believe the contradictory fact exists, right? So basically, in short, no good faith, no impeachment is permissible. And so if we take the example above, right, the witness says he was 20 feet away from the collision, he can be asked if he was more than 100 feet away, right? So in cross-examination, you say, on direct examination, you said that you were 20 feet away from the collision. Are you sure it wasn't closer to 100 feet away? Now, this is where they'll give an answer yes or no. If they say, oh yeah, it could have been, well then you just kind of hammer that point home one last time and move on. If they say, no, I was 20 feet away, you might ask the court to take what's called judicial notice. Basically, it's a fact that's not in dispute, where they measured where this guy was standing, and they measured where the crash occurred, and it was 100 feet away. And if it's not a disputed fact, it'll come as judicial notice. And then you're like, okay, look, the facts are contradictory. What you're telling me is different than what you've said. But you have to have a good faith basis for that belief, right? You can't just get out there and start asking questions that you're trying to poke holes in their testimony, but you don't have any good reason to believe that those issues exist. So with contradictory facts, it gets a little difficult, but usually you can call witnesses to testify that, oh no, it was actually 100 feet away. And then in closing arguments, that's when you make your He was 100 feet away. He said he was 20 feet away, but he was 100 feet away, et cetera, et cetera. When it comes to contradictory facts, you also have to be careful because we are not great as human beings at recalling or observing or characterizing certain things. So one thing that we're really bad is measurements. 20 feet away versus 100 feet away, like, I don't know what 100 feet away from me looks like, right? 20 feet-ish, like, I know something's like 5 feet away from me, 10 feet away from me, I've got that. But the higher we're going, the more, like, I don't know, it becomes. So again, use this carefully so it doesn't look like you're just picking on a person who legitimately was like, dude, I have no clue. So I was 20 feet away, maybe it was 100, I don't know, but I saw it, right? Because at the end of the day, that's what they're going to come back with is, no, it doesn't matter where I was, I saw it, and I saw what I saw. So this is something that you would really tackle in closing arguments. So it brings us to Federal Rule of Evidence 609, prior convictions. So whenever any witness testifies, his or her credibility can be attacked with 1, a prior felony conviction, or 2, any conviction, whether it was a felony or misdemeanor, that involved a, quote, dishonest act or false statement. And so you can bring in, generally speaking, it has to be less than 10 years old. So you can bring in a felony if it's less than 10 years old. So you've been convicted of a felony before, haven't you? And you spent time in jail for that. Like, you can follow that line for a little bit, but it's just enough to get to the jury to be like, oh, this person is a criminal for felonies. For any conviction, right, whether it's a felony or misdemeanor that involves a dishonest act or false statement. This is where we're talking like the guy got charged, convicted of perjury, right? They lied in a previous case, or they talk about fraud, right? So you committed fraud before, right? And that's when you tell somebody one thing and then something else is actually true. Isn't that true? Right? So you kind of just follow there. Now, as I said before, ordinarily it's going to have to be less than 10 years old, calculated from the date of the sentencing or release, whichever is later, right? So they spend 5 years in prison, like you get an extra 5 years. Now, that being said, the court does employ a balancing test, right? So the probative value of the felony conviction has to outweigh its prejudicial effects to the accused, right? So the jury needs to know that this person has been dishonest before, is a felon. If we can't get there, and the jury's like, okay, why are we talking about this? Or we say that it's overly prejudicial, right? That they're going to say, oh, well, he's the best friend of the defendant, and he's already lying because he was convicted of lying before. That might be too prejudicial, right? We don't want somebody making the decision about the defendant based upon somebody else's criminal history. Now, remember, we talked about this before, draw the sting. So if you get up there and you have your witness, and your witness has a felony conviction or has a conviction involving a dishonest act or a false statement, bring it out, right? Bring it out almost right away. Okay, so, Mr. So-and-so, I'm going to jump right in and ask you, have you ever been convicted of a felony? Yes. What was the felony? All right, and you go through it. You say, and you were released when? And so it's been about 10 years since your release, right? And you haven't been charged with anything since then? No. That's where you draw the sting, right? Is that takes all the dust out of the defense attorney or the opposing counsel's sails, because you can get up there and ask them the same questions, but they already answered them. And usually if you have your witness, you're going to try to make them look good. You're going to allow them to explain, right? Cross-examination, you don't allow them to explain. If it's something like perjury, I would hit that home again. Even though the jury's already heard it, they could hear it again. Like, remind them what perjury is. They already lied in a previous trial, so why aren't they lying now, right? So again, draw this thing as best you can. If it's your witness, if it's not your witness, you go on the attack. That being said, we also can look at Rule 608B, prior bad acts. So for an impeachment to be proper for a prior bad act, let me reword it. Impeachment for a prior bad act is permitted, but not frequently used, as many states do not permit the practice, right? So the feds, you can use prior bad acts. States, most of them you can't. Now, the prior bad act of this person has to be probative of the character for truthfulness or untruthfulness, right? So this can get a little ridiculous and it can confuse a jury, right? So you have to be very careful how you approach a prior bad act, if you're even allowed to. Now, when we're talking about prior bad act, it can literally be anything that shows that they're truthful or not truthful. So for instance, if we're talking about a loan application, right? The loan application, you have to list your assets, and you have to list your liabilities, right? Money that you owe, things that you have. And as I'm digging, and maybe it's not even related to the case, as I'm digging through it, I find in your background that you weren't completely honest. Maybe you weren't lying, but like you legitimately like, I don't know. And you misstated what you had. That's a bad act. Now, it does not require conviction? No, right? You just lied on a loan application. Now, if that's probative for your character for truthfulness, which I'm going to argue it is, right, if I'm one who's impeaching you, then it's proper, and depending on the state. Now, this is important. Prior bad acts cannot be proven with extrinsic evidence, okay? So what this means is that the prior bad act must be brought out while the witness is testifying. But if the witness denies the prior bad act, you are basically stuck with the witness's answer, and you cannot contradict it with other evidence. So what we mean by this is you can get there and say, in 2010, you requested a loan, correct? Yes. And on that loan, you were supposed to list your assets and your liabilities, correct? Yes. And on that loan application, you said that you had no outstanding debt. Isn't that true? Yes. In fact, though, you had millions of dollars in outstanding debt. Isn't that true? No. You're stuck. Like that person just shut you down. You cannot bring in the loan application. You can't bring it in as an exhibit, even really talk about it, and argue with a witness. As soon as that witness says no to a prior bad act, something along those lines, it shuts you down. So it's one of those things where it's good to know as a lawyer that anything that goes kind of like, if they try to start proving this person lied at a certain time, as a lawyer, you're going to want to jump on that, right? And make an objection for improper impeachment. So you're kind of stuck with what the witness says. So that's why it's be very cautious if you go down the aisle of prior bad acts. If we look at 608A, this is bad character for truthfulness. Now, bad character for truthfulness is permitted as an impeachment technique, but it is not a cross-examination technique, right? So basically, under the rules of evidence, any fact witness who has testified can have his character for truthfulness attacked by what's called a character witness. Right? So basically what happens is you call, so person testifies, right? Person A testifies. You can call, if they're a fact witness, you can call person A's ex-girlfriend, right? And say, all right, and ask them questions about that person in terms of their character for truthfulness, right? Like, were they honest with you? What happened? Like, you can do that sort of thing, which is kind of weird considering you can't use prior bad acts. Like, once they shut you down, you can't go from there. But if it's a character witness and you want to attack their character for truthfulness, you can call a character witness. Now, that being said, once a fact witness's character for truthfulness has been attacked, the party calling the fact witness then can present supporting character evidence. So basically, they can call another witness to rebut this witness, or they can bring in documents that rebut what this person is saying, right? So generally speaking, all character testimony must be general reputation or personal opinion in form, and is limited to the character for truthfulness or untruthfulness. Now, that being said, the defense, and this is important, the defense cannot call a witness to testify to a defendant's character for truthfulness during its case in chief, so during the defense's case, because their character has yet to be attacked despite the criminal charges, right? So basically, as long as if the other side doesn't like try to attack the defendant's character for truthfulness and they're not taking the stand, you can't call witnesses, right? Because like all you have in front of you is the charges. Otherwise, we're going to say that's going to be really, really, really prejudicial, more so than its probative value. So that being said, that wraps us up for today. The next lecture we're going to look at is exhibits, so basically physical evidence and how to use it. Thank you for listening, and I hope you have a great week.